Good morning, or should I say, good grief. A metric ton of pretrial documents has landed on the docket, and I'm going to do my best to read them out loud to you with minimal commentary. Documents 558 through 574 are motions in limine from the defense. In limine is Latin for at the threshold or at the start. A motion in limine is a legal term that refers to a pretrial motion filed by an attorney to request that the court exclude specific evidence or arguments from being presented at trial, essentially asking the judge to rule on the admissibility of certain evidence before it's ever presented to the jury, with the goal of preventing potentially prejudicial or irrelevant information from ever reaching the jury. To save time, we're going to skip the 3 affidavits that were included with the defense's motions. There aren't any additional details within them this time around. I'm going to try to see how many of these we can group into a single video. At the moment, it looks like documents 575 through 586 will be from the Commonwealth. Let me read you the titles of those ones so that we can have a sneak preview for the second video. All right, so the yellow highlighted bar right here is the dividing line between the defense's motions and where the Commonwealth ones begin. So I'll read you the titles of the Commonwealth's motions, and then we'll kind of double back to the defense's titles. So we can expect that item 575 from the Commonwealth will be Commonwealth's motion in limine to appoint court stenographer, prevent identification of jurors, and impound juror names during the trial. Seems reasonable. Commonwealth's motion in limine for sequestration order. Ooh, this one could be interesting. And for relief from that order for family members of the victim. My prediction is that this one is going to request that witnesses not be allowed in the courtroom ahead of their testimony and or even after they testify, so that in case they need to be recalled or that kind of thing. I was in this role when we adopted our baby during a lot of the court hearings since we had adopted him from foster care. There were times when the judge was working through the termination of his bio parents' parental rights, my husband was able to sit in the courtroom and listen to what was going on, but because I was going to be speaking as a witness, I had to be sequestered in the little alcove just near the courtroom. Boy, and there were some days when I was in that little room for like 7 hours straight before I finally had the opportunity to testify for like 10 minutes. So I'm guessing that's what that one is going to be about. Then we have Commonwealth's motion in limine to allow in-court identification. Commonwealth's motion in limine to admit 1, victim's photograph, and 2, photographs of the victim's injuries as observed by medical providers on January 29th, 2022 from autopsy. The next one is Commonwealth's motion in limine to preclude reference to and redact the manner of death contained on the victim's death certificate. Okay, that, if they're looking to suppress the manner of death from the death certificate, that seems like a problem. I know that there was some controversy about what the death certificate contained from the medical examiner. However, the idea of concealing that seems like it could be confusing and or frustrating for the jury. Okay, the next one is Commonwealth's motion in limine to introduce certified records from the Registry of Motor Vehicles. That's kind of interesting. The next one is their motion in limine of intent to obtain CORI records of potential jurors. And that is, remember last time, the first trial, John Fanning was the one in charge of obtaining the Corey records of the potential jurors. That just shows if they've been arrested for previous crimes or felonies or anything like that. Personally, I feel like this is a bit discriminatory. Um, I really, I understand to an extent why it's being included, but I think that it's a disadvantage for the defense to have that. The next one is Commonwealth's motion for offer of proof prior to defendant calling or summonsing the Norfolk District Attorney and victim witness advocate as witnesses, and request for an order that neither is subject to a sequestration order. So they're saying that um, we want to know ahead of time if you plan to call Michael Morrissey and the victim witness advocate. I can't remember his name off the top of my head. I think it might be Steve something. And where it says request for an order that neither is subject to the sequestration order, that means that they would be allowed to either be in the courtroom or keep up with the trial, like on TV or that kind of thing, and not have to isolate themselves from any of the trial knowledge. Then the next one is Commonwealth's motion in limine regarding, requesting use of chalks and directing both parties to provide visual representations or presentations and chalks prior to using. So chalks meaning essentially the same thing as visual presentations. So they're saying, Judge, please make a rule that if anyone is going to use visual aids, that they be, shared with each other and shared or approved by the judge in advance. Then we have Commonwealth's motion in limine to allow expert Cellebrite demonstration. Then Commonwealth's motion in limine to admit the victim's out-of-court statements relating to his state of mind. Interesting. And finally, Commonwealth's motion in limine to admit results of defendant's blood draw at Good Samaritan Hospital and resulting serum conversion and retrograde extrapolation, which we know is extremely problematic for a number of reasons. And interestingly, but not surprisingly, there are no accompanying affidavits listed separately among the Commonwealth's motions. Now, if we scroll back up to the ones that we're going to be looking at right now for the defense's motions in limine, the first one is a motion to present demonstrative exhibit based on Christina Hanley's testimony. The next one is a motion to exclude irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence. So that's going to be, I'm guessing, probably Aruba, which, remember, during the first trial, the jurors that came forward to the media have all indicated that Aruba was irrelevant anyway. The next one is defendant's motion to impound portions of defendant's motion in limine to exclude certain witnesses before and after testimony. So similar to a sequestration order. Then we have an affidavit that we'll be skipping. Then defendant's motion in limine to exclude certain witnesses before and after testimony. Okay, so that one seems to be, and the next one, which is the redacted version of it, those seem to be the actual motions, and the one that we saw prior to that seems to be accompanying that. Then we have motion in limine for a view. So going back to 34 Fairview to see at least the property and potentially the vehicle. And then defendant's motion in limine to prohibit testimony regarding funds paid to experts for purposes of voir dire. Nice to see that they're getting ahead of that. We have defendant's motion for attorney-conducted panel of voir dire, so of jury selection. Defendant's motion for order prohibiting the Commonwealth and its agents from speaking with or having contact with any witnesses once they have taken the stand. Now, my understanding is that that was supposed to be part of the rules, similar to how presenting exculpatory evidence is part of the built-in rules. And yet David Yannetti requested an additional motion to make sure that the Commonwealth was aware of that. And, they violated it anyway. But this strikes me as similar. They noticed that it was a problem last time. So even though I'm like 99% sure that it's already part of the rules, they are going back in and saying, we're making it a motion so that everyone is really, really aware that this is important to us. Okay, next one is defendant's motion to impound, defendant's motion in limine to exclude irrelevant, inadmissible, and prejudicial evidence regarding alleged harassment and or intimidation of witnesses. I think we can kind of see where that one is heading. And then we have another affidavit. Then defendant's motion in limine to exclude irrelevant, inadmissible, and prejudicial evidence regarding alleged harassment and or intimidation of witnesses. So a few of these, I'm starting to sense a pattern that some of them are kind of paired up. It'll be interesting as we read through them. Next, we have defendant's motion in limine to exclude serum plasma ethanol concentration, blood ethanol concentration conversion, and corresponding retrograde extrapolation analysis. I really hope that that one gets approved by the judge. I know it's in this circumstance, it's a long shot, but I do believe that it would be appropriate in this particular instance. Next, we have the defendant's motion to impound, defendant's motion in limine to exclude witnesses' prior criminal history. Kind of interesting. So impound defendant's motion in limine. Okay, so they're saying they don't want this one to be shared, and they're looking to exclude a witness's prior criminal history. I wonder if this could be Turtle Boy. Like, I'm not saying that he has a criminal history, but I just wonder if, remember how during the first trial, Lolly tried to say that that there was an ongoing grand jury to indict Karen and Aiden for conspiracy to commit witness intimidation. I wonder if it has something to do with that. I'm just speculating right now. The next one is an affidavit. And then finally, like the kind of final one in the pairing there is the defendant's motion in limine to exclude witnesses' prior criminal history. And those ones have not arrived yet to be available for us. I don't know if they will or not, since they include the motion to impound. So I have a space being held open for them at the moment. So let's go ahead and jump into the top motion that we'll be looking at to present demonstrative exhibit based on Christina Hanley's testimony. All right, this motion is 8 pages long, and it is titled Defendant's Motion in Limine to present demonstrative exhibit based on Christina Hanley's testimony. Now comes the defendant, Karen Reed, and respectfully moves this honorable court in limine to present the attached demonstrative exhibit, or quote-unquote chalk, to the jury. This chalk is necessary to clarify critical evidence and will aid the jury in understanding the testimony presented. Factual background. Ms. Reed is accused of the following crimes arising out of the death of Officer John O'Keefe: murder in the second degree, manslaughter while under the influence of alcohol, and leaving the scene of personal injury and death as count 3. On January 29th, 2022, Mr. O'Keefe is captured on video surveillance footage leaving the Waterfall Bar and Grill with a cocktail glass from the bar in his hand. The Commonwealth claims that this glass remained in Mr. O'Keefe's possession at the time that he arrived at 34 Fairview Road. On to page 2. And was broken in the early morning of January 29th, 2022, outside the Albert residence after being struck by the taillight of Ms. Reed's vehicle. Over the course of several searches, law enforcement recovered numerous pieces of glass from the yard outside of 34 Fairview Road and the rear bumper of Ms. Reed's vehicle. The source of the glass recovered from the bumper of Ms. Reed's vehicle and the lawn of 34 Fairview Road is material and relevant to this case. At the first trial, Christina Hanley, a forensic scientist at the Massachusetts State Police Crime Lab, testified for the Commonwealth about the pieces of glass recovered from the scene and from the bumper of Ms. Reed's vehicle. This testimony lasted more than an hour and spanned 37 pages of the trial transcript. Throughout her extensive testimony, Ms. Hanley discussed 16 distinct pieces of glass recovered from 34 Fairview Road and the bumper of Ms. Reed's vehicle. These 16 pieces of glass originated from 4 separate sources. Some pieces of glass came from the same source, meaning that they were originally a part of the same object. Ms. Hanley's testimony is very intricate and difficult to follow without some sort of visual aid. During the trial, Ms. Hanley herself frequently needed to refer to her notes and request that counsel repeat questions to keep the various pieces of evidence she was discussing clear. To remedy this problem, the defense proposes the use of a demonstrative aid consisting of one chart spanning one page, containing representations of all recovered pieces of glass, and graphics depicting which pieces came from which source of glass. The proposed chalk tracks directly with Ms. Hanley's testimony and report. The chalk starts by identifying 4 basic categories based on where the pieces were recovered from and who they were brought in by. Each group of pieces is called an item. These items are 1. Items 3-2, the base of the cup recovered from the scene. 2. Items 3-3, 5 pieces of glass taken from the bumper of Ms. Reed's car, viewed by the laboratory as one item. Number 3, items 7-12, 9 pieces of glass taken from the scene by Trooper Buchanan, viewed by the laboratory as one item. And 4, item 7-14, a single piece of glass taken from the scene by Trooper Proctor. Each smaller piece of glass within items 3-3 and 7-12 has an additional lettered label referencing the individual pieces itself within the broader item. Okay. Item 3-3 contains the sublabels A, B, C, D, and E, each letter representing an individual piece of glass. These sublabels are the same as those assigned by Ms. Hanley in her testimony and in the lab report. Similarly, the 9 pieces of glass in item 7-12 are labeled A, B, C, D, E, F, and then I, K, and L, skipping the letters G and H as was done in Ms. Hanley's testimony and in her report. What about J? Maybe we'll get to it. For each individual piece of glass, the chart includes a graphic next to the corresponding label based on which other pieces of glass that piece matched. The graphics in the columns next to each label correspond directly with Ms. Hanley's testimony, particularly the testimony on pages 75-76 and 90-92 of the June 5th, 2024 trial transcript. Each sublabel has a graphic next to it, indicating which other pieces of glass it matches. Through these graphics, the chalk summarizes Ms. Hanley's conclusions into a simple chart, which Ms. Hanley confirmed was an accurate representation of her testimony. Argument. To assist the jury in visualizing Ms. Hanley's granular and essential testimony, the defense proposes the attached demonstrative exhibit, or chalk, to aid the jury, which is attached hereto as Exhibit A. A demonstrative exhibit is something presented to the jury to help them better follow and understand the evidence, but is not evidence itself. And then they cite where that quote comes from. On to the next page. Demonstrative exhibits can take many forms, including live demonstrations, charts, and even literal chalk figures on a blackboard. Demonstratives are particularly useful where a party presents complicated testimony that may be difficult for a jury to understand or visualize. Allowing the use of a 34-page bar chart as a chalk to depict hours defendant billed Medicaid for a particular period. So they're referencing a different time when one was used for a different case as precedents. These sorts of aids are appropriate where 1, they are relevant, 2, they are not more prejudicial than probative, and 3, they sufficiently resemble the actual event so as to be fair and informative, or they are fair representations of the facts the chalk aims to clarify. Finally, the court has broad discretion in determining whether to admit a demonstrative aid, coming to us from a case from 1980. 1. The proposed chalk is highly relevant. Ms. Hanley's testimony is clearly relevant, i.e., whether any of the glass on the bumper matches the cocktail glass at the scene or is from a different unidentified source, and goes directly to whether the evidence in this case supports that Ms. Reed struck John O'Keefe or the cocktail glass in question. The relationships between the other pieces of glass are critical to understand the scene. Therefore, the chalk, which summarizes Ms. Hanley's testimony about this glass, is also highly relevant, especially given that the chalk provides much needed clarity to an otherwise complicated issue. Without a chalk, the jury would need to be able to either accurately record or memorize the source of each piece of glass and each piece's relationship to all other pieces in order to make sense of Ms. Hanley's testimony. The complexity of this testimony is underscored by Ms. Hanley's frequent references to her notes and requests for counsel to repeat questions, particularly questions about the relationships between the pieces of glass. Kind of sounds like this visual aid would be of use to Ms. Hanley as well as to the jury. Of course, referencing notes and requesting the repetition of questions is permissible and even preferable to ensure that testimony is accurate. However, if a lab expert has trouble keeping track of the labels of evidence that she analyzed herself, surely the jury would have even more trouble making sense of this critical evidence, making the chalk not only relevant but essential. Okay. Argument 2. The chalk would not prejudice the Commonwealth. Any prejudice that may be argued to stem from the chalk is far outweighed by its probative value. This chalk does not prejudice the Commonwealth in any way. Rather, the proposed chalk would be highly probative in relation to Ms. Hanley's testimony, which would otherwise require jurors to memorize and differentiate the titles and sources of various pieces of glass with labels that closely resemble one another. This is true. This has been my headache for the past week, trying to sort all of those pieces and give them labels. It is merely a depiction of which glass pieces match others and a visual representation of Ms. Hanley's live testimony. And then they give a source citation. Given the chalk corresponds so closely with Ms. Hanley's testimony, a witness for the Commonwealth, it is difficult to see how the chalk could be remotely prejudicial. Even if the court finds that there is some prejudicial tendency to the proposed chalk, it is far outweighed by probative value. The Supreme Judicial Court of Massachusetts has been liberal in allowing demonstrations and chalks even when there is potential for extreme prejudice. In Commonwealth versus McGee, where the defendant was accused of killing his partner in front of their, 6-year-old child, The Supreme Judicial Court of Massachusetts upheld the allowance of a physical demonstration by that child, oh God, then 10 years old, of the position in which he saw his mother on the couch when she was killed. Oh God. Commonwealth versus McGee, 2014. In support of this decision, the court highlighted that testimony about the decedent's position on the couch at the time of her murder was crucial in determining whether the premeditation element of murder in the first degree was met. Given that a live demonstration by a child of the position his mother was in when she was killed, was permitted as more probative than prejudicial. This proposed chalk, which simply depicts Ms. Hanley's testimony, is certainly more probative than prejudicial, if prejudicial at all. And then argument section 3 says the proposed chalk directly mirrors Ms. Hanley's testimony fairly and accurately. As described in detail above and as seen in the chalk itself, the chalk is merely a summary of Ms. Hanley's testimony. The 4 categories displayed in the chalk, the labels used in the chalk, and the connections between each piece of glass are all drawn directly from Ms. Hanley's testimony. In fact, during the first trial, Ms. Hanley was shown this exact chalk, which she confirmed on the record was an accurate reflection of her testimony. Conclusion: without the chalk, Ms. Hanley's testimony will be exceptionally difficult for the jury to follow, which would seriously detract from the important evidence Ms. Hanley will present. Given the great relevance of the contents of this chalk, its lack of prejudicial tendency, and the tight relationship between the chalk and Ms. Hanley's testimony, the proposed chalk should be permitted. For the above reasons, Ms. Reed respectfully requests that this honorable court allow the attached chalk to be presented to the jury. And that takes us to the bottom of page 6, top of page 7, where we have the signatures of all of Karen's attorneys. All right, next we have item or document number, I should say, 559. And here, let me get it centered on the screen. This is the defendant's motion in limine to exclude irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence. And I believe that this document is 10 pages long. Now comes the defendant, Karen Reed, and respectfully moves this honorable court in limine to exclude any references to the irrelevant, inadmissible, and prejudicial events that purportedly transpired, just like we predicted, in Aruba on December 31st of 2021. As grounds for this motion, the defendant states that the proffered or pro-offered evidence is not relevant to any material issue in this case. Should the court find that the evidence is relevant, any potential probative value of this proffered evidence is outweighed by the substantial risk of unfair prejudice to Ms. Reed. And then they give a citation. Factual background. Ms. Reed is accused of the following crimes arising out of the death of Officer John O'Keefe. And this we're getting pretty used to, so I'm just going to kind of hop over that little paragraph there. The defense suspects that the Commonwealth will again seek to admit testimony regarding a completely irrelevant verbal argument between Ms. Reed and a woman named Marietta Sullivan, which occurred in Aruba on December 31st, 2021, for the sole purpose of trying to assassinate Ms. Reed's character in the eyes of the jury. At Ms. Reed's first trial, every single witness unequivocally testified that there was no history of violence whatsoever in Ms. Reed and Mr. O'Keefe's relationship, and that the two of them were in good spirits on the night of January 28, 2022. Despite this, the Commonwealth repeatedly elicited inadmissible testimony regarding a verbal incident that occurred in Aruba 1 month prior between Ms. Reed and a third party, which had no logical relationship to the crimes charged. The Commonwealth has no reliable evidence to suggest that the Aruba incident had anything whatsoever to do with John O'Keefe's death a full month later on January 29, 2022, or that this remote and isolated incident was even a point of contention in Ms. Reed and Mr. O'Keefe's relationship after that trip. At the first trial, the Commonwealth called Laura and Marietta Sullivan to testify about a highly inflammatory incident in which Ms. Reed apparently got angry at another woman, not the decedent, because she purportedly believed that Mr. O'Keefe had kissed that woman. The Commonwealth intentionally admitted this prior bad acts and character evidence for no reason other than to sully Ms. Reed's character in the hopes that the jury would indict her based on the fact that she was, in Marietta Sullivan's words, quote unquote, an a-hole. At trial, Laura Sullivan admitted that she was not present during this verbal exchange between Marietta and Ms. Reed, so her testimony about the December 31st, 2022 incident in Aruba is almost entirely comprised of inadmissible hearsay. Despite the court's limiting instructions about bad character and propensity evidence, the Commonwealth was permitted to elicit prejudicial testimony from Laura Sullivan that Mr. O'Keefe purportedly called Ms. Reed, quote unquote, crazy, and that he had insinuated that he was unhappy in their relationship. Marietta Sullivan's trial testimony was also extremely prejudicial to Ms. Reed. Her retelling of the verbal dispute with Ms. Reed was not probative of any material fact or element in this case, and it culminated with Marietta telling the jury decidedly that Ms. Reed sucks. As set forth herein, this evidence must be excluded. Argument Part 1. The Aruba incident constitutes inadmissible prior bad acts and character evidence, and any potential relevance is outweighed by the risk of unfair prejudice to the defendant. Motions in limine concerning the introduction or exclusion of purportedly relevant evidence are properly made and considered before and during trial in advance of the evidence being offered. That comes to us from a case from 2023. The purpose of a motion in limine is to prevent irrelevant, inadmissible, or prejudicial matters from being admitted into evidence, and in granting such a motion, a judge has discretion similar to that which she has when deciding whether to admit or exclude evidence. That comes to us from a case in 1983 and 2023, and another one in 2023. It is a fundamental rule that the prosecution may not introduce evidence that a defendant previously has misbehaved, indictably or not, for the purpose of showing his bad character or propensity to commit the crime charged. Comes to us from a case from 2003. Although this type of evidence is sometimes admissible for other relevant purposes, such as to prove a, quote, common scheme, pattern of operation, absence of accident or mistake, identity, intent, or motive, these exceptions are not without limitation, end quote, from a case in 1986. Let's see, here my sister was born. And another case also from 1986. Similarly, although evidence of a hostile relationship between a defendant and his spouse may be admitted as relevant to a defendant's motive to kill the victim, quote, such evidence should not be admitted if it relates to events which occur at a time too remote from the killing, end quote, in a case, holy macanoli, in a case from 1881, animosity between husband and wife 3 years before murder, too distant to be probative of husband's motive. And another case from 1959, evidence of defendant's husband's adulterous relationship, which terminated 7 months before wife's death, not probative of motive to murder. They've referenced this before. I remember those. Temporal remoteness, temporal meaning time, is not an exercise in line drawing. Rather, a reviewing court focuses on the logical relationship between the prior bad act evidence and the crime charged. That comes to us from a case in 2020. Here, there is no logical relationship. In order for evidence of a prior hostile relationship to be relevant to a defendant's motive to kill the victim, the evidence must actually establish a prior hostile and violent relationship between the victim and the defendant. Comes to us from a case in 2022. Prior acts evidence, including police testimony about a domestic dispute requiring law enforcement response, and witness testimony about multiple physical disputes between defendant and victim in order to show the nature of the relationship. Comes to us from a case in 2021. Evidence including defendant's prior arrest for domestic violence, multiple restraining orders, and pending divorce proceedings was admitted to show the nature of the relationship, and that is from a case in 2018. Evidence of defendant's prior threat to stab victim to death was introduced to show the nature of the relationship, a case from 2017. Evidence including extreme physical violence, multiple emergency room trips, and threats to kill the victim was admitted to demonstrate the nature of the relationship, as well as defendant's intent, motive, and absences of mistake. And finally, it sounds like, a case from 2016, evidence including extreme physical violence and threats with a firearm was admitted to show nature of relationship and motive. This case law is not comparable to this incident during which Ms. Reed briefly became angry with another woman, not the decedent, because she believed that Mr. O'Keefe had kissed that woman. There was zero physical violence here, no threats of violence, no police involvement necessary, and absolutely no history of violence in Ms. Reed and Mr. O'Keefe's relationship. Moreover, even when this type of evidence might be relevant for some limited purpose, the evidence must be excluded if its probative value is outweighed by the risk of unfair prejudice to the defendant. And I certainly agree this is more prejudicial than probative. We have a footnote that says Section 404(b)(2) permits the court to exclude evidence of a crime, wrong, or other act that is offered for a proper purpose, e.g., to prove motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident, if the risk of unfair prejudice simply outweighs the probative value of the evidence. This is a more exacting standard than the standard set forth in Section 403, excluding relevant evidence for prejudice, confusion, it's cut off, W-A-S, a waste of time, okay, or other reasons, which permits the court to exclude relevant evidence if the danger of unfair prejudice, confusing the issues, misleading the jury, God, the Commonwealth is so good at that, undue delay, wasting time, or needlessly presenting cumulative evidence substantially outweighs the probative value. Compare Evidence Code 403 with Evidence Code 404(b). That is because bad act and propensity evidence is, quote unquote, inherently prejudicial, and the risk of improper use is enormous. That comes to us from a case in 2014 and another in 2017, where offered to establish motive in prosecution for first-degree murder, quote, testimony regarding the charges in the defendant once he began using drugs, end quote, including the statement that the defendant had become, quote, a little more violent, end quote, was considered more prejudicial than probative. Okay, on to page 6. Massachusetts courts have long held that where evidence of prior bad acts is relevant for purposes such as intent or motive, it should be excluded if its probative value is outweighed by the risk of unfair prejudice to the defendant, even if not substantially outweighed by that risk. Comes to us from a case from 2015, emphasis added. Here, testimony by Marietta Sullivan that Ms. Reed became angry with Marietta, not the decedent, on December 31st, 2021, because she believed that Marietta had kissed her boyfriend, John O'Keefe, is simply not probative as to whether Ms. Reed had an intent to murder John O'Keefe on January 29th of 2022. This event was remote in time and was clearly not an issue between O'Keefe and Ms. Reed on the night in question, as evidenced by video surveillance footage from the Waterfall Bar and Grill on the night in question and the testimony of 8 witnesses, all of whom agreed that the couple appeared happy and in good spirits. There is no logical relationship between the Aruba incident and the crime charged. The Commonwealth's attempt to characterize this misunderstanding as some sort of quote-unquote turning point in Ms. Reed and Mr. O'Keefe's relationship is off base and unsupported by the evidence. The sole purpose of the Commonwealth's attempts to admit this evidence is to sully Ms. Reed's character by allowing Marietta Sullivan to testify that Ms. Reed, quote-unquote, sucks. If we are to believe the Commonwealth's best evidence, i.e. that Ms. Reed said, quote unquote, go F yourself to Marietta when she temporarily believed that she had observed Marietta kissing her boyfriend on New Year's Eve in Aruba, that evidence is simply not probative of a motive to murder Mr. O'Keefe more than a month later when the parties were, by all accounts, in good spirits. In order for there to be a quote-unquote logical relationship between the prior bad acts evidence and the crime charged as required by Commonwealth versus Payno in 2020, the jury would need to believe that Ms. Reed reacted with a verbal quote-unquote go F yourself when she believed that she had observed adulterous behavior on December 31st, 2021, but then subsequently flew into a murderous rage a month later when this event was remote in time and not the subject of any arguments on the night in question. This type of reasoning defies logic. Ms. Reed's short-lived anger was not even directed at Mr. O'Keefe, and her apologetic conduct after the incident demonstrates that she knew the quote-unquote kiss could have been a misunderstanding. The only reason for the admission of this evidence is to sully Ms. Reed's character and prejudice the jury against her. Ms. Reed reasserts here that this evidence has no probative value regarding the crimes for which she has been indicted. However, even if the court finds that this evidence is relevant, any marginal relevance of Ms. Reed's temporary belief that O'Keefe kissed another woman 1 month prior might have, in terms of evidencing a quote-unquote hostile relationship or intent to murder, is far outweighed by the prejudicial inflammatory effect that it will have on the jury. Argument Part 2 says, the Commonwealth must be prohibited from calling witnesses to testify to inadmissible hearsay for the purpose of attempting to show a hostile relationship. Moreover, Massachusetts courts have long held that the admission of hearsay statements for the purpose of showing a hostile relationship between the defendant and the victim is not permissible because it would, quote, entirely eviscerate the rule's important purpose of securing the correctness and completeness of testimony through cross-examination, end quote, from a case in 1997. The Commonwealth's argument in prior proceedings that this testimony is admissible in order to show the defendant's state of mind is misguided. Again, the events in Aruba took place a month before John O'Keefe's death, and there is no evidence to suggest that Ms. Reed was still upset about it on the night of January 28, 2022. Here, testimony by Laura Sullivan regarding the irrelevant and inherently prejudicial Aruba incident must be excluded because this witness has nothing to testify about other than inadmissible hearsay and prejudicial character evidence. Indeed, during the 2024 trial proceedings, the Commonwealth chose to put Laura Sullivan on the stand to testify about an incident that she did not witness in Aruba on December 31st, 2021, involving Ms. Reed, Mr. O'Keefe, and her sister, Marietta Sullivan. Laura Sullivan was also permitted to testify about her completely irrelevant negative impressions of Karen during the planning of the Aruba trip, i.e. that Karen told her she needed her own bathroom and that she didn't want to share a room with John's kids. The Commonwealth then elicited additional inadmissible and prejudicial hearsay testimony from Laura, who told the jury that Mr. O'Keefe told her that Karen is quote-unquote crazy during a later conversation on the night of December 31st, 2021, and that on January 2nd, 2022, John insinuated that he was unhappy in their relationship. And we have a footnote here that says, note, this unhappiness was allegedly communicated non-verbally and solely via Mr. O'Keefe's body language, namely a shrug and an eye roll. Not only is this inadmissible hearsay, but it it's an interpretation of a gesture, not an assertion of actual words that Mr. O'Keefe said to Laura, and thus calls for speculation. That is a very good point. Okay. Notably, Massachusetts courts have long held that the admission of hearsay statements for the purpose of showing a hostile relationship between the defendant and the victim is not permissible because it would, quote, entirely eviscerate the rule's important purpose of securing the correctness and completeness of testimony through cross-examination. And that comes to us from a case in 1997. Thus, all of Laura Sullivan's testimony regarding the Aruba trip constitutes prejudicial and inadmissible hearsay, which must be excluded. And the conclusion states, for the above reasons, Ms. Reed respectfully requests that this honorable court exclude any reference to the December 31st, 2021 incident in Aruba. And then we have the signature of Karen's attorneys. All right, next we have document number 560, and fortunately this one is a quickie. It's just a single page, and then the second page is the signatures. Defendant's motion to impound portions of defendant's motion in limine to exclude certain witnesses before and after testimony. Now comes the defendant, Karen Reed, and respectfully moves this honorable court for an order impounding portions of defendant's motion in limine to exclude certain witnesses before and after testimony, namely, the portion of the motion referencing text messages that are subject to a protective order issued in connection with this case and Exhibit A containing a copy of those text messages. Good cause exists for the impoundment of this information because it is subject to a protective order. In support of this request, Ms. Reed hereby submits 2 copies of the defendant's motion, 1, an unredacted copy of defendant's motion for the court file, and 2, a copy of the motion with all reference to and copies of the text messages that are subject to a protective order, redacted such that they are not visible to the public. And that helps us to understand why there are kind of groups of different documents that have similar titles to them. Now we kind of understand what's happening with that. Respectfully submitted for the defendant, Karen Reed, by her attorneys. And then the second page is where their signatures are. All right. Okay, so that means that we're skipping over the affidavit, which, like I said, it doesn't have any kind of bonus material in it. And then 562 would have been the unredacted one, which is going to be impounded. And now we're looking at 563, the redacted version, which appears to be 10 pages long. So let me make it a little bit larger here. All right, hopefully y'all can see that. And it's titled Defendant's Motion in Limine to Exclude Certain Witnesses Before and After Testimony. Now comes the defendant, Karen Reed, and respectfully moves this honorable court in limine to exclude certain witnesses from the courtroom before and after the testimony at trial in this matter. Rule 21, Sequestration of Witnesses of the Massachusetts Rules of Criminal Procedure states that upon his own motion or the motion of either party, the judge may, prior to or during the examination of witness, order any witness or witnesses other than the defendant to be excluded from the courtroom. And that is from a case in 2007. Quote, the power of the judge to control the progress and, within the limits of the adversary system, the shape of the trial, is universally held to include the broad discretionary power to sequester witnesses before, during, and after their testimony, end quote. Citing a case from 1976, another from 1893, another from 1974, one from 1973, from 1979, 77, 75, 68, let's see, 1892 and 1974, Ms. Reed specifically requests that the court exercise its broad discretion to exclude Brian Albert, Nicole Albert, Colin Albert, Julie Albert, Chris Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins from the courtroom before and after their testimony at trial. As this court likely recalls, after they testified, members of the Albert and McCabe families proceeded to sit in the gallery with the O'Keefe family, facing the jury sporadically throughout the remainder of the trial, including closing arguments. Following trial, a juror reported to Vanity Fair magazine that he or she felt it was, quote, utterly inappropriate, end quote, that the Albert and McCabe families were able to, quote unquote, stare down the jury from their position in the courtroom gallery. One juror reported to Vanity Fair magazine that he or she felt intimidated by the presence of the Albert and McCabe families, calling their presence in the courtroom's small gallery facing the jury, quote, completely and utterly inappropriate, end quote, noting that the Albert and McCabe families were substantial focal points of the trial. The juror noted how unbelievable it was that the families, quote, were allowed in to stare down the jury, end quote. And then they give the source citation, and then a big chunk on the bottom of that page is redacted, and the top paragraph of the next page is redacted, and it picks up, this was extraordinarily prejudicial to Ms. Reed. The alleged third-party culprits, Brian Albert, Colin Albert, and Jennifer McCabe, all sat in the gallery during the closing arguments, directly facing the jury, which according to at least one juror was intimidating. And they cite a case from, they don't tell us, but it does take us to a footnote which says, courts have recognized that when a witness or person stares down a jury, that can make the jurors feel timid or fearful. See Commonwealth versus Gordon, a case from 1998, defining intimidation as, quote, making timid or fearful, inspire or affect with fear, end quote, or to put in fear, quote, for the purpose of compelling or deterring conduct. Intimidation by the aforementioned witnesses in the context of this case took the form of, quote unquote, staring down. And a case from 2010 tells us, noting the juror intimidation during a trial where jurors were, quote unquote, concerned to leave, as there were, quote unquote, a lot of people just kind of staring down and making the jurors uncomfortable. As previously noted, an individual does not need to do actual harm in order for an act to be considered intimidation. All right, so let's hop back up. As the jurors heard through testimony, the Alberts and McCabe families have deep connections and familial ties to multiple state police forces and local governments. In addition, Mr. O'Keefe, a Boston Police Department officer, was a part of this tight-knit law enforcement community. By sitting with the family of John O'Keefe and continuing to face the jury for parts of the remainder of the trial, at least one juror felt intimidated by what he or she perceived as the Alberts, quote unquote, staring the jury down. On to page 4. Here, the judge has broad discretion to order the sequestration of witnesses before or after their testimony at trial. A defendant has a constitutional right to a fair trial to be decided by an impartial jury, free from intimidation and undue influence. Given that at least one juror reported feeling intimidated by the presence of certain witnesses toward the end of the trial, Ms. Reed respectfully requests that the court exercise its broad discretion to issue a sequestration order excluding Brian Albert, Nicole Albert, Colin Albert, Julie Albert, Chris Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins from the courtroom before and after their witness testimony to prevent further prejudice to Ms. Reed. A little bit interesting that Carrie is not listed here. And if you're wondering why Paul and Aaron are not mentioned, I'm assuming that they would be allowed under the opportunity for the victims to have relatives in the courtroom. They would be waived from this kind of exclusionary sequestration order anyway. So that's probably why the defense didn't even bother to mention them, even though I'm sure that Karen would love to not have Paul's crotch, right in her face the whole time. Conclusion: for the above reasons, Ms. Reed respectfully requests that this honorable court exercise its broad discretion to exclude Brian Albert, Nicole Albert, Colin Albert, Julie Albert, Chris Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins from the courtroom before and after their testimony at trial. And then we have the signature page. Let me just make sure that there's nothing juicy. We do have an Exhibit A, but it is entirely redacted. Let me just, confirm all the way through redacted. Well, guys, we are making great progress. And the next document, which is item number 564, is titled Defendant's Motion in Limine for a View. Now comes the defendant, Karen Reed, and respectfully moves this honorable court, pursuant to Massachusetts General Laws 234A, subsection 69A, to order that the jury be taken on a view of the alleged crime scene. And then they quote a case from 1933 that says, the power to inform itself by a view, we have an ellipses, is inherent in a court at common law, end quote. Ms. Reed specifically requests that the court order a view of 1, 34 Fairview Road in Canton, Massachusetts, and 2, the exterior of the 2021 Lexus LX SUV bearing the Massachusetts plate, hereinafter the vehicle. Ms. Reed further requests that the vehicle be towed to the public roadway in front of 34 Fairview Road, Canton, Massachusetts. Finally, Ms. Reed requests that the honorable court permit Ms. Reed to attend the view, subject to any reasonable restrictions the court deems necessary. Yeah, I think she deserves to get to see her car, right? And that comes to us from a case in 1996 and another from 2015. So the law provides that the court may order a view by a jury and panel to try a criminal case. Ms. Reed states that permitting the jury to view the crime scene located at 34 Fairview Road and the vehicle at issue, i.e. the alleged murder weapon, would assist the jurors in reaching a verdict. Allowing the impaneled jury to view the crime scene located at 34 Fairview Road will be particularly useful because the lawn appears to be much more expansive in photographs than it does in person. In addition, allowing jurors to visually inspect the vehicle will assist the jurors in assessing whether Mr. O'Keefe's injuries were consistent with having been struck by any portion of the vehicle. Let me just interrupt to add, I wish that they would also show some visual aids of what other vehicles that have struck pedestrians, like of the body damage to the vehicle, and I mean potentially even to the victim, of the injuries and vehicle damage that occur with a vehicle strike, just so that the jury has something to compare it to know if what they're seeing is normal or if what they're seeing is unusual. While we're dreaming, I would also love for the defense to present almost like, how you see on TV sometimes there are lineups or even photographs that they'll show a witness and they'll say, which of these people looks like the person that you witnessed doing the crime? I wish that there was a chance to say which of these tail lights most closely represents what you observed, and show the witnesses a picture of a taillight that is cracked, a picture of cracked with a hole, a picture of fully broken, and a picture of absolutely destroyed, and ask each witness to identify which most closely represents what they observed. I feel like that would be extremely helpful. Now, I'm not sure if that's legal, but we can dream, right? Okay, getting back to this. Let's see. Although what is seen on the view may be used by the jury in reaching their verdict, in a, quote, strict and narrow sense, a view may be thought not to be evidence, end quote. Properly speaking, quote, no evidence should be taken or testimonial comments made during the taking of a view. Okay, so that's similar to the Murdaugh view, where no one was supposed to speak. And that comes to us from 2007. During a view, the essential features of a crime scene may be pointed out by counsel, it being permissible, merely to point out to the jury, quote, marks, matters, and things, but not otherwise to speak to the jury. And I think that's why Adam Lawley kept trying to get the jury to look at remember he kept apparently trying to get the jury to look at the center console, which was probably an attempt to get them to look at the rear view camera screen. As with the decision whether to hold a view, the decision to allow a defendant to be present is within the trial judge's discretion. And that quotes a case from 1965 and another from 66. Ms. Reed respectfully requests that the court allow her to be present for the view, subject to any reasonable restrictions that the court deems necessary. And that is the end. It says, for the reasons above, Ms. Reed respectfully requests that this honorable court allow this motion for review. So that's all she wrote on that one. And we have just 2 pages worth, essentially, of the lawyer's signatures. So let's move on to the next document. All right, document 565 is the defendant's motion in limine to prohibit testimony regarding funds paid to experts for purposes of voir dire. And remember, this has been a hotly contested issue because of the somewhat slimy way that the Commonwealth tried to make it seem inappropriate that the defense had paid for the travel expenses of the experts, the ARCA experts that were hired by the FBI. Now comes the defendant, Karen Reed, and respectfully moves this honorable court in limine to exclude testimony regarding expenses incurred by Ms. Reed for expert voir dire. Given that these, and that, expert voir dire being the jury selection interviews and the interviews of the witnesses, like when they do the Daubert hearings to determine if the witnesses are qualified. That form of interviewing is also referred to as expert voir dire. Given that these expert expenses were incurred based solely on the request of the Commonwealth and the mandate of the court, their inclusion in testimony would not be probative of any fact or of consequence and would only be unduly prejudicial towards the defendant. And it's true, making it seem like she has purchased an opinion would be very prejudicial. Factual background. In advance of both the first and second trial in this matter, the Commonwealth requested and the court ordered in-person voir dire for defense expert witnesses, including Dr. Daniel Wolf, Dr. Andrew Rentschler, and Dr. Marie Russell. As a result, Ms. Reed had to expend significant resources to pay for out-of-state experts to travel to Norfolk Superior Court for voir dire hearings, which spanned multiple days. To the extent that the Commonwealth seeks to cross-examine these experts regarding any fees that have been paid to testify in connection with this case, the Commonwealth should be precluded from eliciting testimony regarding any fees expended to have experts testify at voir dire hearings, which were conducted at the Commonwealth's request. And the argument states, the first item in the argument says, expenses incurred by Ms. Reed as a result of expert voir dire are irrelevant. The fees and expenses related to expert voir dire are entirely irrelevant to expert credibility and do not make any fact of consequence more or less probable. Discussion of the fact that an expert witness is compensated for their time is acceptable so that juries may assess expert credibility and bias, coming to us from 2012, holding that while discussion of an expert's standard fee is acceptable, suggestion that the expert is a quote-unquote hired gun is impermissible, coming to us from 1979. However, testimony about fees and expenses incurred as a result of voir dire have no bearing on an expert's credibility at trial. This is particularly the case here, where in-person voir dire was conducted at the request of the Commonwealth and where a significant portion of voir dire expenses came from travel and lodging. Discussion of fees and expenses incurred by the defense for expert voir dire would not provide the jury with any additional clarity about expert motivation or biases. The in-person voir dire of experts was conducted at the Commonwealth's request. Moreover, the defense would have no way of clarifying the issue on redirect without eliciting the fact that there was a voir dire hearing, which is information that the jury should not be privy to and would not understand. Voir dire fees and expenses are separate from potentially relevant fees and expenses accrued at the trial and therefore should be excluded. Moving on to argument part 2, discussion of expert voir dire expenses would be significantly more prejudicial than probative. Even if the testimony regarding fees and travel expenses incurred for experts' testimony at a voir dire hearing is deemed relevant, it would be far more prejudicial than probative. Evidence deemed relevant may be excluded in a variety of circumstances, including where probative value is outweighed by risk of, quote, unfair prejudice, confusing the issues, or misleading the jury, end quote. Exclusion is appropriate where the prejudice created by the testimony is unfair and, quote, may cause the jury to base their decision on something other than the established propositions in the case, end quote. Further, on cross-examination, a party may ask a witness questions pertaining to potential bias. However, where the, quote, relevance of the proposed evidence is of no more than marginal value to the party conducting the cross-examination, the judge has discretion to exclude the evidence, end quote. Discussion of expenses and fees for expert witnesses incurred as a result of the lengthy voir dire hearings would be highly prejudicial while lacking probative value. Expert fees and costs related to the voir dire required by the court has no bearing on expert bias at trial. However, because these expenses were high, particularly whereas here at least one expert had to testify at 2 separate voir dire hearings, the jury may come away with a negative assumption and feelings towards Ms. Reed. They may make assumptions about her financial situation or believe that the costs and expenses are related specifically to expert trial testimony. The jury could feel that the experts are, quote unquote, hired guns based on these inflated numbers, or come to judge Ms. Reed based on assumptions about her financial situation. Such emotional considerations may impermissibly cloud the judgment of the jury and could lead to decisions based on these emotions rather than, quote, the established propositions of the case, end quote. On to the next page, the prejudice would not be remedied by an explanation of the expert voir dire process. In fact, such explanation would only serve to further prejudice Ms. Reed and to confuse the jury. I agree with that. That's a reasonable statement. When expert voir dire is conducted out of the presence of the jury, this separation may be viewed as a tool to prevent bias towards or against the expert. And they give a quote from Commonwealth versus Richardson that says, although it is for the court to determine whether a witness is qualified to testify as an expert, there is no requirement that the court specifically make the finding in open court upon proffer of the offering party. Such an offer and finding by the court might influence the jury in its evaluation of the expert, and the better procedure is to avoid an acknowledgement of the witness's expertise by the court, end quote. That's from 1996. While Richardson is specifically focused on whether a judge must qualify an expert as an expert in front of the jury, it illuminates important considerations about the expert qualification process that are useful in this context. Ultimately, disclosure of fees and expenses incurred for expert voir dire would create an inaccurate and improper image of Ms. Reed's financial situation, causing unfair prejudice and a serious risk that the jury make credibility determinations based on the fact that voir dire was conducted at all. Both results would be unfairly prejudicial, far outweighing any potential probative value, and therefore testimony about fees and expenses incurred by Ms. Reed for expert voir dire should be excluded. And argument point 3 says discussion at trial of expert voir dire expenses would undermine the voir dire process and principles of fairness. The purpose of experts sharing their standard fees on the stand is to allow the jury to hear and consider potential bias. Voir dire may be used to determine an expert's qualifications and the admissibility of the facts underlying their testimony. And that comes to us from a case in 2012 and 2021. Allowing testimony at trial regarding expenses incurred as a result of the voir dire hearings would undermine both the purpose of expert court fee disclosure and the integrity of the expert voir dire process. If voir dire expenses are shared at trial, it could incentivize parties to insist on in-person expert voir dire to drive up litigation costs, as if that isn't what's already happened from the Commonwealth, for the other side, and then present the inflated number to the jury, creating a misleading and prejudicial image of the other party. Well, gosh, defense, you're kind of kicking out the knees of the Commonwealth's ugly plan here. Come on, you're exposing them. This incentive would pervert the voir dire process, turning it into a potential trial weapon as opposed to a tool used to assess expert qualifications. Conclusion: allowing testimony about the costs incurred by Ms. Reed during the expert voir dire process would be irrelevant, far more prejudicial than probative, and would ultimately undermine the integrity of the voir dire process. Therefore, Ms. Reed respectfully requests that discussion of the expenses incurred as a result of in-person expert voir dire be excluded from all testimony at trial. And then we have the signatures of her attorneys and the certificate of service, and that is that. All right. Our next one is document 566, defendant Karen Reed's motion for attorney-conducted panel voir dire. Now comes the defendant, Karen Reed, and respectfully moves this honorable court pursuant to General Law, Chapter 234A, subsection 67D, from the Massachusetts Rules of Criminal Procedure of the Rules of the Superior Court, 2017, for attorney-conducted panel voir dire of the jury venire in order to determine whether such potential juror stands indifferent. Ms. Reed requests the defense counsel be permitted to conduct panel voir dire of the jury venire on the following subjects: whether previous experiences with the jury system or criminal legal system, characteristics of the case, including the media attention, or personal characteristics or concerns of the prospective jurors would impair their ability to be impartial, whether prospective jurors are biased in favor of law enforcement or have law enforcement-related knowledge, whether prospective jurors hold strong personal beliefs about operating a vehicle under the influence of alcohol, whether prospective jurors have been involved in or have close friends or family members who have been involved in domestic violence relationships, whether prospective jurors or anyone close to them have been involved in a motor vehicle crash, whether prospective jurors have been the victim of any violent crimes, and whether prospective jurors understand and can be impartial in light of the procedural protections afforded to defendants in criminal trials. Ms. Reed reserves the right to ask reasonable follow-up questions to each prospective juror pursuant to Rule 6.3 C of the Rules of the Superior Court from 2017. Now, we have the argument. I just want to say this feels somewhat narrowly tailored based on what we know occurred with the jury foreman previously, who was a former New Hampshire police officer who had been the victim of a motor vehicle collision when he was on duty as a police officer, and he subsequently changed his profession entirely to become a physician's assistant. To me, that's what page 1 seems to be kind of trying to dig into a little bit to make sure that a similar situation doesn't happen on this next go round. Okay, argument. Part 1. Per General Law, Chapter 234A, subsection 67D, and Superior Court Rule 63B, the Superior Court is required to permit the requested attorney-conducted voir dire. Part of the Sixth Amendment right to an impartial jury is, quote, the adequate voir dire to identify unqualified jurors, end quote, from 1992. Prior to 2014, there was no right to attorney-conducted voir dire in Massachusetts, and whether to permit attorney-conducted voir dire in any given case was entirely within the discretion of trial court judges. See a case from 2018, and one from 1850, and one from 2014 and 2016. However, in an effort to better protect the right to an impartial jury and ultimately a fair trial, see General Law, Chapter describing voir dire as a way to examine, quote, whether the juror related to either party or has any interest in the case, or has expressed or formed an opinion, or is sensible of any bias or prejudice, end quote. The Massachusetts legislature amended the general law from that section. It was recodified in 2014. So they kind of updated the language and details surrounding it. Through that amendment, the legislature created a right to attorney-conducted voir dire. See Dabney from citing general law, yada, yada. The current version of the statute, so amended, states that, quote, in addition to whatever jury voir dire of the jury venire is conducted by the court shall permit, upon the request of any party's attorney or a self-represented party, the party's attorney or self-represented party to conduct an oral examination of the prospective jurors at the discretion of the court. And then it continues on to page 3. See also Rule 63B of the Rules of the Superior Court 2017. The trial judge shall allow attorney or party voir dire if properly and timely requested, end quote. The Massachusetts Supreme Judicial Court has interpreted this most recent version of the statute as creating a right to attorney-conducted voir dire, and accordingly has expressly stated that, quote, trial judges must permit attorney-conducted voir dire jury selection upon request, end quote. That comes to us from 2024. Accordingly, because this request for attorney-conducted voir dire was properly and timely made, that takes us to a footnote and is teeny tiny. Let me see if I can make it a bit bigger here. As per Superior Court Rule 63A, on or before the final trial conference in a civil case or final pretrial conference in a criminal case, or 5 business days before trial if no such conference is scheduled, the parties shall submit in writing any requests for attorney/party voir dire, motions in limine concerning the method of jury selection, proposed subject matters or questions for inquiry by the parties or trial judge, any proposed supplemental questionnaire, any proposed preliminary legal instructions to the venire or juror panels, the location within the courtroom where jurors and parties will stand or sit during voir dire, and any other matter setting forth the party's position regarding empanelment. Rule 63A of the Rules of the Superior Court 2017. This request for attorney-conducted voir dire has been submitted in advance of the final pre-trial conference as requested. Then we'll hop back up to the top. Let's see, where was it? Okay. So accordingly, because this request for attorney-conducted voir dire was properly and timely made, the court is required to permit attorney-conducted voir dire. Well, hopefully that means that this one will be approved with little fanfare. Okay, argument point 2. All questions proposed by defense counsel are consistent with the guidance of Superior Court Rules, Rule 6, and necessary to ensure Ms. Reed's Sixth Amendment right, and so should be allowed. While trial court judges must grant attorney-conducted voir dire when properly and timely requested, judges retain discretion over the scope of attorney-conducted voir dire. And then we have a quote that says, the court may impose reasonable limitations upon the questions and time allowed during such examination, including but not limited to requiring pre-approval of the questions, end quote. Superior Court Rule 6, hereinafter, quote unquote, Rule 6, states that judges may permissibly use that discretion to place, quote, reasonable restrictions on the subject matter, time, or method of attorney or party voir dire. Rule 6.3f of the Rules of Superior Court 2017 and precludes attorneys from asking a small number of questions on particular subjects. It takes us to our second footnote, which is hefty. As per Superior Court Rule 6e, quote, counsel and parties may not ask, end quote, questions framed in terms of how the juror would decide this case, which would be prejudgment, including hypotheticals that are close or specific to the facts of this case. Any hypotheticals may trigger this rule must be presented to the judge before trial. Next, questions that seek to commit jurors to a result, including, without limitation, questions about what evidence would cause the jurors to find for the attorney's client or the party. Item 3 says questions that have no substantial purpose other than to argue an attorney's or party's case or indoctrinate any jurors. Fourth, questions about the outcome in prior cases where the person has served as a juror. Oh, I didn't know that was not allowed. It seems like that one sometimes gets asked every now and again, including the prior votes of the juror. Okay, maybe it's a more specific thing. Or the verdict of the entire jury. No, that includes everybody. Questions in the presence of other jurors that specifically reference what is written on a particular juror's confidential juror questionnaire. Interesting. Okay. So, critically though, Rule 6 also includes guidance that judges, quote, should generally approve a reasonable number of questions, end quote, intended to reach certain permissible ends or inquire into certain relevant topics. Rule 6.3c of the Rules of Superior Court 2017. These questions include, first, seek factual information about the prospective juror's background and experience pertinent to the issues expected to arise in this case. Second, may reveal preconceptions or biases relating to the identity of the parties or the nature of the claims or issues expected to arise in the case. Third, inquire into the prospective juror's willingness and ability to accept and apply pertinent legal principles as instructed. And fourth, are meant to elicit information on subjects that controlling authority has identified as preferred subjects of inquiry, even if not absolutely required. Rule 6 also explicitly instructs that, in doing so, judges should consider the goals outlined in Rule 6.1, which includes permitting parties and their attorneys to participate in the process of identifying potential juror biases. Rule 6.1 of the Rules of Superior Court 2017. And we have a subsection A that says, the subjects that defense counsel has proposed for attorney-conducted voir dire are subjects into which Rule 6 instructs inquiry should be allowed. Most of the proposed voir dire subjects will aid defense counsel in evaluating prospective jurors' ability to be impartial by eliciting specific evidence of relevant biases. We're going to, as soon as we finish the sentence, we'll go back to the footnote. Such as bias in favor of police officers or against people who are accused of operating a motor vehicle under the influence of alcohol. And the footnote says specifically, legal defense counsel seeks to inquire of the jury whether previous experiences with the jury system or criminal legal system, characteristics of the case, including the media attention, or personal characteristics or concerns of the prospective jurors would impair their ability to be impartial. Whether prospective jurors are biased in favor of law enforcement or have law enforcement-related knowledge, whether prospective jurors hold strong personal beliefs about operating a vehicle under the influence of alcohol, whether prospective jurors have been, and so this footnote must continue, on the bottom of this page, involved in or have close friends or family members who have been involved in domestic violence relationships, whether prospective jurors or anyone close to them have been involved in a motor vehicle crash, and whether prospective jurors have been the victims of any violent crimes. So that's the end of the footnote. And the main text continues and says, consequently, questions on these subjects should be allowed as questions that, quote, seek factual information about the prospective juror's background and experience pertinent to the issues expected to arise in the case, end quote. Rule 63C1 of the Rules of Superior Court 2017 and, quote, may reveal preconceptions or biases relating to the identity of the parties or the nature of the claims or issues expected to arise in the case, end quote. Rule 63C2 of the Rules of the Superior Court 2017. And then they ask us to see a case from 2002 discussing, quote, the value of encouraging questioning sensitive to the possibility that bias may arise out of a family relationship with law enforcement, end quote. Even a familial tie to law enforcement is not dispositive of bias. And they then cite a case from 2004, quote, the view of the violent nature of the charge of murder, it would have been preferable had the judge asked the veneer collectively whether any of the prospective jurors or a member of their immediate family had ever been the victim of a violent crime. We would expect judges to ask the question in cases of violent crime, end quote. With respect to proposed questions on the subject of the bias due to media attention, in particular, Massachusetts courts have recognized the potential biasing effect of extensive pretrial media coverage of a case. See Commonwealth v. Mack, 2019, quoting Commonwealth v. Tulin from 2011, where pretrial publicity renders the risk of juror bias particularly acute or especially significant. Both this court and the United States Supreme Courts have emphasized the need for adequate voir dire, end quote. Ms. Reed's case has been highly publicized both in Massachusetts and nationally. Since the criminal case began, newspapers and news networks, including the Boston Globe, there's going to be lots of footnotes here, Boston News, Boston 25 News, the New York Times, Vox, NBC, CBS, and the Washington Post, each one of those having their own footnote giving the more specific information of the topics that were publicized, to name a few, have been covering Ms. Reed's criminal case, some publishing about the case repeatedly over the course of months. Given the significant media coverage of this case and the resulting likelihood that many potential jurors will have learned information about the case through the news, it will be particularly difficult to impanel an unbiased jury for Ms. Reed's second trial. As such, allowing defense counsel to question jurors on the subject of media attention the case has garnered is necessary to ensure the impartiality that Ms. Reed is constitutionally entitled to. Questions on the remaining proposed subject of whether prospective jurors understand and can be impartial in light of the procedural protections afforded to defendants in criminal trials should be allowed as, quote, inquiries into the prospective jurors' willingness and ability to accept and apply pertinent legal principles as instructed, end quote. Rule 63C3 of the Rules of the Superior Court 2017. And what I have on the screen right now, if you are looking to get into deeper reading, or you wonder if you may have missed any of these publications, I encourage you to take a screenshot of this. I wonder if I can make it a little bit bigger for you so that you can look those up if you so choose when you have the opportunity. Now, on to the top of page 7, Rule 63C thus affirmatively counsels that each of the defense counsel's proposed voir dire subjects should be allowed. And then argument subsection B says ensuring Ms. Reed's constitutional right to an impartial jury requires allowing inquiry into the proposed subjects. Allowing defense counsel to inquire into the proposed subjects not only complies with Rule 6.3c, but is also necessary to protect Ms. Reed's right under the Sixth Amendment of the United States Constitution to an impartial jury, which hinges in part on adequate voir dire. See Morgan, some sort of case from the U.S. Constitution, Amendment 6. In this case, adequate voir dire requires not only that this court follow the Supreme Judicial Court mandate to grant a timely and proper motion for attorney-conducted voir dire, but also that the court allow attorney-conducted questioning on proposed subjects that meaningfully aid in the identification of unqualified jurors. And that's not an insult. They're just talking about people who should be disqualified out of the fear of potential bias or discrimination. And that comes to us from a case in 1992. Quote, voir dire plays a critical function in assuring the criminal defendant that his constitutional right to an impartial jury will be honored. Without an adequate voir dire, the trial judge's responsibility to remove prospective jurors who will not be able impartially to follow the court's instructions and evaluate the evidence cannot be fulfilled. End quote. Rule 6.1 of the Rules of the Superior Court, 2017, quote, this rule provides a standard procedure for each civil and criminal case unless otherwise ordered by the trial judge, while permitting attorneys and self-represented parties a fair opportunity to participate in voir dire so as to identify bias, end quote. Given the defense counsel's proposed questions contravene no part of Rule 6, fall within the type of question which Rule 6 counsels should be allowed in reasonable number, and are necessary to ensure adequate voir dire, and thus Ms. Reed's constitutional right to an impartial jury, this court should permit defense counsel to inquire into all subjects included in its proposed jury questionnaire. And then the conclusion starts at the top of page 8. For the above reasons, Ms. Reed respectfully requests that this honorable court grant her motion for attorney-conducted panel voir dire of the jury veneer. Respectfully submitted. And then the attorneys have signed off, and let's confirm that there is no bonus material at the end. All right, there we go. Let's queue up the next motion. Next, we have item 567, defendant's motion for order prohibiting the Commonwealth and its agents from speaking with or having contact with any witnesses once they have taken the stand. And remember, during the first trial, a number of the most critical witnesses, at least on behalf of the Commonwealth, and I think Trooper Buchanan being one of them, possibly Jen McCabe, possibly one of the Alberts, their testimony was staggered either overnight or over the weekend. And so there was some concern that they may have met with the prosecution to have kind of off-the-record conversations in the meanwhile. And again, I feel like this is one of the rules that is like generally covered in the proper procedures and practice, but I get the sense that this is requesting a separate motion be made just to communicate to everybody, hey, we're aware of this, and it's essential that everyone obey these rules. So now comes the defendant, Karen Reed, and respectfully moves this honorable court to issue an order prohibiting the Commonwealth and its agents, including but not limited to the prosecution, law enforcement, and victim witness advocates, from speaking with or having any contact with any witness once the witness has taken the stand. During Ms. Reed's first trial, the defense learned that the Commonwealth was having improper conversations with witnesses while they were in the middle of their testimony. See? For example, on cross-examination, Brian Albert indicated he had spoken with Assistant District Attorney ADA Adam Lawley over the lunch hour while the court was in recess during the middle of his testimony. When asked what they had discussed, he initially denied speaking about the substance of his testimony, but then later admitted that ADA Lawley had discussed some of the topics he wanted to ask him on redirect. God, that's so scummy, isn't it? Quote, he maybe mentioned one thing he may ask me, just he was going to ask about what happened at the house in the morning. You know, some of the questions on redirect. That's all. Yeah, thanks. End quote. As grounds for this motion, Ms. Reed states that the court has discretion to prohibit communication between witnesses and attorneys or third parties, and they cite a case from 1989. Here's the argument. In order to preserve the, quote, truth-seeking function of the trial, end quote, the court should prohibit agents of the Commonwealth from communicating with any witness once the witness has taken the stand. This is of particular concern during a recess or lunch break, quote, in which there is virtual certainty that any conversation between the witness and the lawyer would relate to the ongoing testimony, end quote. For similar reasons, the Massachusetts Rules of Criminal Procedure permits a judge to exclude a witness other than the criminal defendant from the courtroom when they are not testifying. Massachusetts Rules of Criminal Procedure 21, the sequestration of witnesses, quote, serves an important function in preventing one witness's testimony from being inadvertently molded by the testimony of other witnesses, end quote. Massachusetts Rules of Criminal Procedure 21, reporters note, the same danger that a witness's testimony may be molded by conversations with others is present when the witness speaks with the prosecution or other agents of the Commonwealth during breaks in their testimony. And then we get right to the conclusion. For the above reasons, Ms. Reed respectfully requests that this honorable court issue an order prohibiting the Commonwealth and its agents, including but not limited to the prosecution, law enforcement, and victim witness advocates from speaking with or having any contact with any witness once that witness has taken the stand. Respectfully submitted for the defendant, Karen Reed, by her attorneys. And then they all sign off with a certificate of service at the bottom. Item 568 is an itty bitty, but it is associated with several of the other motions that we're going to be taking a look at. Defendant's motion to impound defendant's motion in limine to exclude irrelevant, inadmissible, and prejudicial evidence regarding alleged harassment and or intimidation of witnesses. Now comes the defendant, Karen Reed, and respectfully moves this honorable court for an order impounding defendant's motion in limine to exclude irrelevant, inadmissible, and prejudicial evidence regarding alleged harassment and or intimidation of witnesses. Good cause exists for the impoundment of this motion because it makes reference to grand jury proceedings. Respectfully submitted for the defendant, Karen Reed, by her attorneys. And there we go. We have the signatures and certificate of service. So let's see what this pertains to. All right. So the pattern has become when we have this, I had been saying pair, but what I should have been saying was trio, because we've seen that there's a request to impound that actually precedes a redacted version of the motion and an unredacted version of the motion. And actually, now that I think about it, they are generally accompanied by an affidavit as well. So a quartet of motions. And so this is going to be the redacted version of defendant's motion in limine to exclude serum plasma ethanol concentration, blood ethanol concentration conversion, and corresponding retrograde extrapolation analysis. And this is labeled item 571 at the top. Now comes the defendant, Karen Reed, and respectfully moves this honorable court in limine to exclude evidence of a serum plasma ethanol concentration test performed by Good Samaritan Hospital at 9:08 a.m. on January 29, 2022. By extension, Ms. Reed necessarily moves to exclude the blood ethanol concentration conversion performed by the Massachusetts State Police, as well as the corresponding retrograde extrapolation analysis. And then the next paragraph says, as grounds for this motion, Ms. Reed states that, as acknowledged by MSP forensic scientist Nicholas C. Roberts in his report, quote, the ethanol results used in the reports were provided by an external party. The testing to obtain the ethanol results was not performed at the Massachusetts State Police Crime Laboratory, and therefore the reports do not fall under the laboratory's scope of accreditation. End quote. See Exhibit A, May 4th, 2022, Serum Plasma Conversion Report. See also Exhibit B, June 6th, 2022, Retrograde Extrapolation Report. Since the Commonwealth cannot establish that the blood test result administered by Good Samaritan Medical Center is reliable for the purposes of a criminal prosecution, the serum plasma ethanol concentration result and the corresponding blood ethanol conversion and retrograde extrapolation, which derive their results from the initial result, should be excluded as unreliable and not the product of reliable principle and methods. See Massachusetts General Evidence, subsection 702. Factual background. On January 29, 2022, around 7:26 a.m., Ms. Reed was admitted to Good Samaritan Medical Center as a result of the acute grief reaction she experienced after learning that her then boyfriend, Officer John O'Keefe, had passed away. In addition to evaluating her, the hospital performed blood work and a urine drug test, which included tests for the presence of drugs and alcohol. Ms. Reed tested negative for any drugs for which the hospital screened. The hospital, however, recorded an alcohol level in Ms. Reed's blood of 93 mg/dl. Using the value from the test conducted by the hospital and without ever having applied for a warrant to themselves test Ms. Reed's blood, as would be the normal course in a prosecution involving any aggravated form of operating under the influence, Massachusetts State Police performed a conversion of the reported 93 mg/dl result to a blood ethanol concentration ranging from 0.078 G percentage to 0.083 G percentage based on 3 different conversion factors from May 4th, 2022. Using that conversion, Mr. Roberts then conducted a retrograde extrapolation on June 6th, 2022. So they're saying that he did math. That's what he did. He didn't touch the blood. He didn't analyze the blood. He doesn't even know if those numbers have been tampered with. He just did the math equations. And it says the serum plasma ethanol concentration. Okay. In both reports, Mr. Roberts explicitly notes that the serum plasma ethanol concentration obtained from Good Samaritan Medical Center, quote, was not performed at the Massachusetts State Police Crime Laboratory, and therefore this report does not fall under the laboratory's scope of accreditation, end quote. See Exhibit A, see also Exhibit B. After the first trial on September 17, 2024, the Toxicology Unit Administrative Manual updated conversion factors used by the Massachusetts State Police Crime Lab to align with ANSI/ASB Best Practice Recommendation 122, First Edition 2024 document. Per a new report dated October 10, 2024, authored by forensic scientist Hannah Knowles, the new serum plasma ethanol concentration estimated by the Massachusetts State Police Crime Lab is now between 0.078% and 0.082%. Okay, what was it before? Okay, so it's 1/100th of, I'm so sorry. I wish I could. The third digit from the decimal point has been reduced by 1. So it used to be 0.083, and now the range, the end of the range is 0.082%. Exhibit C, October 10th, 2024, report by Hannah Knowles. Moreover, in Knowles' report, she uses a time interval of 8.5 hours with an additional 2-hour allowance from the time of 12:45 a.m., the time of the alleged incident, which is what the Commonwealth has claimed, but we know that Karen was home at that point. She was back at One Meadows by 12:36. In an attempt to account for uncertainties associated with the drinking history of the subject prior to the time interval, our calculations determined that Ms. Reed's blood alcohol content, quote unquote, could have been between, quote, 0.14 G percentage and 0.28 G percentage at 12:45 a.m. on 1/29 of 2022. There is a footnote. I promise we'll come back to it. This calculation assumes that the subject's BAC had peaked at or prior to the start of the time interval, 12:45 a.m., indicating that the subject had consumed no ethanol 0.5 to 1.5 hours prior to the time interval. It's a little bit confusing. Let's hop down to the footnote that says, this range differs from the range testified to by the forensic scientist used by the Commonwealth at the first trial, Nicholas Roberts, who indicated that the range would have been between 0.13 G percentage and 0.29 G percentage. So that's what they had at first calculated her blood alcohol content to be. Okay. Argument. 1, because both the initial serum plasma conversion report and the subsequent retrograde extrapolation analysis are based on a blood test about which the parties lack essential information, including testing procedures and type of testing, the blood test results should be excluded. Retrograde extrapolation is, quote, a mathematical calculation used to estimate a person's blood alcohol level at a particular point in time by working backward from the time the blood alcohol test was taken, taking into consideration rates of both absorption and excretion. End quote. Commonwealth versus Senior from 2001. The SJC has held that, generally speaking, retrograde extrapolation analysis meets the Daubert-Lanigan standard for admissibility. Oh, that's interesting. Breathalyzer test results are generally admissible without the need for retrograde extrapolation, without the need for expert testimony when taken with, quote unquote, a reasonable time defined by the SJC as 3 hours. So this is outside the range. After operation of a vehicle. Commonwealth versus somebody or other, 2007. They lay out a narrow exception in which expert testimony is required when the Commonwealth is proceeding under an quote unquote impaired ability theory as opposed to a per se theory, and a test is administered outside of the 3-hour window, necessitating retrograde extrapolation. Expert testimony is required. Just last year, the Supreme Judicial Court addressed the issue of a defendant's consent to a blood test in a prosecution for simple and aggravated forms of OUI. In companion cases, they list a case from 2024 and a second one from 2024. The court held that the consent requirement of Massachusetts General Laws, Chapter 90, subsection 24(1)(e), only applies in prosecutions for simple OUI under GL Chapter 90, subsection 24(1)(e), rather than to any of the aggravated forces of OUI. Accordingly, whether Ms. Reed consented to the alcohol blood test or not is not at issue here. Boy, that's a very slippery slope. But I will say that it feels like I can understand where you would want to shape the rules so that consent isn't necessarily required, because then someone who is legitimately drunk driving could just not give consent and they'd automatically escape without consequence. But on the other hand, it feels like what they're doing here is kind of endorsing the idea of fleeing the scene, as we know that Chris Albert did, as we know that I believe that Tristan Morris, I think I just read recently that Tristan Morris had fled the scene of a drunk driving crash. And we know that Paul O'Keefe was in a drunk driving crash, but did not, to the best of my knowledge, he did not flee the scene. But you certainly don't want to create a law that would encourage people to use that practice to escape consequence either. So I understand that it is kind of a tricky thing, but at the same time, you don't want to create a situation where the person, as Karen was, not immediately arrested for anything because she hadn't done anything. And now many, many, many hours have since passed where she could have, gotten back to the house to search the house with Jen and Carrie and taken a swig of a drink. What New England child hasn't had the experience of reaching for a stray glass of what they think is water on the end table only to take a big gulp of vodka, right? I mean, it's kind of a rite of passage. So it wouldn't surprise me if there was a stray glass from the night before laying around that she might have had a swallow of. Who knows? We don't know because she wasn't in custody of the police. So I think it's a very tricky situation. Okay. Just last year, the Supreme Judicial Court addressed the issue of defendants' consent to a blood test in a prosecution for simple and aggravated forms. Okay, I think we read through that. What is at issue, however, is that the parties lack essential information about how Good Samaritan Medical Center drew and tested Ms. Reed's blood. It is standard practice in prosecutions for OUI and its aggravated forms for police to request and be granted a warrant so that they can themselves test defendant's blood through a certified analyst. And they provide the code for that in accordance with the provisions of that same code. While these requirements pertain only to analysts working for the state police and not to hospital personnel, and they cite a case from 2010, they are in place to ensure that blood testing for ethanol undergoes a standardized, reliable, repeatable procedure. And we have another footnote that, we can handle right now. Okay, so the footnote says 50 MAPRAC subsection 5.26. The admissibility of any given test result will be governed by the adherence to the policies and procedures, and while strict adherence may not be required, any variance will certainly affect the weight given to the evidence by the fact finder. Regulations for the analysis of blood are contained in 501 CMR 2.18 to 2.20. The Massachusetts State Police utilize gas chromatography, well, you get the idea, chromatography testing, rather than enzymatic immunoassay testing, which presumably was used by the hospital here. And then we have footnotes 3 and 4, so we'll hop to those. ANSI, National Accreditation Board, Certificate of Accreditation for the Massachusetts State Police Forensic Services Division Crime Laboratory. They provide a website that is also a PDF, and then they cite another source with the title Case of Acute Hepatic Injury and Elevated Ethanol Levels in a Non-Alcoholic Adult. And that is from some journal from 2019. So moving back up to the main text, in the medical records provided under the chemistry section, there is an annotation regarding the drug testing which states, quote, "This report is intended for use in clinical monitoring and management of patients. It is not intended for use in employment-related drug testing." Oh, really? Or court-related proceedings. Samples are not routinely tested for adulteration and are assumed to be within the normal physiological pH range of 5 through 8. See attached page of Good Samaritan medical records. The alcohol result is beneath this annotation. It is not clear whether this annotation applies only to the urine drug screen or to the alcohol result as well. Wow. And if I am recalling correctly, during the first trial, a motion in limine was made to also exclude this information for the reasons we have discussed, and Bev allowed it through anyway. But this explicitly says that it is not intended for use in court-related proceedings. That's really important. That is, wow. Okay, it continues. Regardless, the defense should not have to guess. The Commonwealth should have, at minimum, provided documentation from the hospital regarding how the alcohol test result was obtained, through what procedure, by whom, and what manner or testing was used, i.e. gas, I should have known we wouldn't be past this word, chromatography, or enzymatic testing, the latter of which would yield a higher result. Absent this information, the Commonwealth is unable to establish the reliability of this initial result on its face. In light of the fact that the MSP, Mr. Roberts, and Ms. Knowles each separately acknowledged in their respective reports that the serum plasma ethanol concentration test does not meet the accreditation standards for reliability outlined in 501 CMR 2.0, we know with certainty that the serum plasma ethanol concentration test was at very least conducted according to an entirely different scientific protocol. What are we even doing here? If the jury, you tell me, if the jury had access to that bit of knowledge that we just learned, that it specifically said that this was not to be considered in court because it wasn't consistent with the practices of calculating the amounts that the judicial system requires, would they even have been hung up on the lesser includeds of count 2? Wow. Okay. It continues, the defense does not take issue with the generally accepted scientific practice of retrograde extrapolation itself, but rather with the data upon which it was based. Without reliable foundational information about the initial serum plasma result, the serum plasma conversion to blood ethanol concentration, and the retrograde extrapolation from the converted number is not reliable. More precisely, the Commonwealth has not provided any information about the initial result from the hospital that would indicate that the subsequent analyses by Mr. Roberts and or Ms. Knowles are accurate. Instead, 3 parties involved in this BAC test have expressly disclaimed the legal veracity of these results. And then they cite the legal code, which states that a certificate signed and sworn to by a chemist of the Department of the State Police or by a chemist of a laboratory certified by the Department of Public Health, which contains the results of an analysis made by such chemist of the percentage of alcohol in such blood, shall be a prima facie evidence of the percentage of alcohol in such blood, end quote. The analysis of Miss Reed's blood was not in fact made, at least not completely, by the chemist who signed and swore the certificate, as is admitted to in the reports by the MSP, Mr. Roberts, and or Miss Knowles. In testimony at trial, Mr. Roberts admitted that while the standard lab testing procedure is to conduct 2 separate tests within the laboratory with Ms. Reed's sample, he conducted no testing himself and merely assumed that the hospital's test was accurate. Both of their analyses were conducted with data that they did not collect themselves. Yeah, they only did the math. Mr. Roberts himself confirmed that an unreliable base for calculations, like we have here, is a serious problem for the reliability of the extrapolation result. Quote, you do have to base the extrapolation calculation on good. Your starting blocks have to be good. So you have to know the time in which the blood was drawn, the time of the incident, and essentially what your value was for your BAC. All three of Mr. Roberts' key factors are not clearly known. Moreover, the prior retrograde extrapolation was not in keeping with ANSI ASB best practices, and thus, and all I can hear in my ears is thus, this is appeal fodder, this is appeal fodder. The new forensic scientist, Hannah Knowles, has now issued a report with a new and different range of BAC, further underscoring the unreliability of the extrapolation in this case. Accordingly, the serum plasma conversion and the retrograde extrapolation result should be excluded. Addressing the issue of pure evidentiary admissibility, GL, General Law, Chapters 233, subsection 79, tells us that, quote, records kept by hospitals shall be admissible and may be admitted by the court in its discretion as evidence in the courts of the Commonwealth, and this next part is in bold and underlined, so far as such records relate to the treatment and medical history of such cases. Emphasis added. Similarly, Commonwealth versus Dyer expands the medical records generated for evaluation and treatment purposes to not constitute testimonial evidence and may be admitted into evidence. 77 Mass Appeal Court 850-854 from 2010. Both the statute on point and seminal case on medical record admissibility pose conjunctive requirements. Treatment and medical history and evaluation and treatment. So when they say conjunctive requirements, it's saying that's the representation of the and that is separating each of those terms. So treatment and medical history. So they're not mutually exclusive. They're in conjunction with one another. And evaluation and treatment in conjunction with one another, not separately on their own. The common factor between the two authorities is quote unquote treatment. Ms. Reed's visit to Good Samaritan Medical Center on January 29, 2022, and the records produced therefrom were explicitly not part of any process of the administration of medical treatment. Commonwealth versus Malone, and then Massachusetts Appeals, 2010, the same year as Dyer, found that when a defendant's blood test was, quote, not connected to medical treatment, end quote, new quote, the Commonwealth's failure to meet the statutory requirements means that the documented hospital records themselves cannot be admitted under the General Law, Chapter 233, subsection 79, hearsay exception. How in the world was this allowed the first time? Therefore, Ms. Reed's serum plasma ethanol concentration results should be excluded. Conclusion. For the above reasons, Ms. Reed respectfully requests that the blood test result from Good Samaritan Medical Center, the serum plasma conversion and retrograde extrapolation evidence be excluded. And then we have the signatures of all the attorneys and the certificate of service. Let me know if you guys would like to hear the first trial's motions in limine about this so that we can compare and contrast the differences to see if these concerns were brought up the first time around and this is a repeat of it, or were they not? I mean, I'm kind of curious myself. Okay, let's take a look at our next motion. We're doing such a good job. Let's see. All right, now we have 572, which is motion to impound defendant's motion in limine to exclude witnesses' prior criminal history. And it's a quickie. It says, now comes the defendant, Karen Reed, and respectfully moves this honorable court for an order impounding defendant's motion in limine to exclude witnesses' prior criminal history. Good cause exists for this impoundment of this motion and supporting exhibit because it contains reference to confidential arrest records. And then we have the signatures of the attorneys and the certificate of service. So now that we have finished reading through all of these motions, we have the motions in limine from the Commonwealth that I'll put in a separate video so that we can kind of keep them separated. But then just now, as I was double checking that I hadn't missed any, I saw that there's a handful of additional documents that have just been posted for the defense. So I think that those will necessitate a third video today. So stay tuned. And in the meanwhile, I appreciate you spending time with me. And I hope that I'll see you in the next video. Until then, take care of yourself, take care of each other, and take care of our community. I love you.